am so excited to see all of you again this morning. I'm Rachel Robinson, Vice President at MedTech, and it's just so great to have everyone joining us at 9 a.m. on this wonderful Wednesday morning. So we will kick things off in just a moment, but I wanted to give you just a few quick reminders. If you have not hit mute to make sure that you are muted, please do so we can minimize all the background noise for our speakers. Also, we will be taking questions. Absolutely, the ladies will explain to you how that's going to work, but please feel free to put those into the chat at the bottom of the screen throughout the program. So, as questions kind of come in, Mian will be, working with Jamie and Emily on handling those. So I would be remiss if I didn't say a huge thank you to Greenberg Traurig for putting this together. I know that you all are going to learn a ton, and we could not do what we do without their incredible support. So thank you all so much for doing this. And I am going to turn things over to Mian to introduce our speakers.
Thank you, Rachel. We wanted to thank Rachel, Brian, and MedTech for this opportunity to present our two-part webinar, Legal Toolkit for Early Stage MedTech Companies. My name is Mian Wong. I'm a shareholder at Greenberg Traurig. Our firm has been a longtime supporter of MedTech for over 10 years. David Dykman, our Boston office co-managing shareholder and the co-chair of the firm's life sciences and medical technology practice, serves on the board of directors. We've co-hosted several events, including several MedTech Partnering Days, which is an annual event that connects some of New England's most innovative emerging MedTech companies with strategic partners to maximize opportunities for collaboration, new business development, and market expansion. Companies include J&J, Medtronic, Boston Scientific, Zoll, Novartis, and many others. Our firm has much experience representing medical technology companies, early stage to public med tech companies. We can help form companies, protect patents and IP, help with employment, real estate, regulatory matters, litigation, M&A, and IPOs. With 2,200 attorneys in 40 offices worldwide, we can serve MedTech companies around the world. Our Boston office has 75 attorneys and much MedTech expertise. In this first part of our webinar, my colleagues Emily Ladd-Kravitz and Jamie Burke will discuss issues to consider in entity formation, founder agreements, funding, and patents and trademark protection. Emily is a shareholder at the firm and the co-chair of the firm's emerging tech practice group. She focuses her practice representing venture capital funds, private equity firms, other institutional investors and companies in connection with a wide variety of corporate and transactional matters, including mergers and acquisitions, private placements, minority investments, venture capital financings, and corporate governance matters. Jamie is a registered patent attorney and focuses her practice on patent prosecution and worldwide patent portfolio management. So we will pause at the end of each speaker's portion for some questions, as well as leave time at the end of the presentation for a Q&A session. All right, Emily.
Thank you, Mian. So I'm going to give you an overview of things to think about when you're forming a company, and then when you're taking your first or second round of financing. We're going to be very high level today and keep this as quick as possible to leave time for questions. But if you have questions, please drop them in the chat or follow up with us afterwards. So for any of you who haven't chosen your entity or maybe haven't gone through a formation process, the basic question we start with is the choice of entity. And you've probably all heard that there's corporations and there's limited liability companies, LLCs. And then you choose Delaware or other states. And a lot of people say, well, why are so many companies organized in Delaware? And that has just become practice because Delaware has very well settled case law on the corporate side. So it's very, very common for a company to be organized as a C corporation in Delaware, which just means it is it's a typical corporate structure, and a C corporation is a tax designation so that profits and losses and income doesn't flow through to your investors, which is something that venture capital funds in particular look for tax treatment purposes. You'll also see these days LLCs are popping up more frequently. That used to be used as a tax structuring mechanism as well, because that would be not 2 levels of tax. So that was considered tax advantageous, especially for founders. The problem with that is it creates pass-through tax, but there are ways to organize as an LLC and be treated like a corporation. So when you're setting up your entities, talk to your lawyers and talk to your accountants. And that's really what's going to guide you on how to structure. And also think about who you're going to take money from, because a Delaware C corporation is by far the most common structure, especially if you're looking for institutional money. And part of that is it makes people comfortable and they know how things are going to come out if there were ever a question that goes to the court about stockholder claims. And sometimes it's easiest just go with what everyone knows and keep things simple. One of the things is when you're thinking about how to structure, you'll see, particularly in the life sciences space and med device space, you will often see companies set up with a holding company structure with several LLCs or pass-through corporations underneath for discrete technologies. So talk to your counselors about how you envision your products developing, and will you create discrete products and discrete technologies that maybe you would want to spin off and sell separately or license separately, and that you would want to house separately. And Jamie may talk about this a little bit in terms of how you keep your patents. There are a lot of different ways to keep your IP, and whether you keep those in separate vehicles so that those are all in one location and not in your operating company. All of those are things that should be thought about and can be structured later, as long as you have the basic structure set up in the beginning. So the next thing we're going to talk about are your basic startup documents that you're going to look for. So when you just form your company, you need a basic set of documents to be a legally formed company. And if you're a corporation, that would be a certificate of incorporation in Delaware. In some states, it's called an articles of incorporation. You need bylaws. Those are your 2 governing documents that set out how the company operates, how the board is formed, what the voting rights are of the stock classes, whether or not you have multiple stock classes, very basic information. And then once you take in investors, your certificate of incorporation will also talk about who gets their money back first and things like that on the economics. Other things that you maybe want to think about when you first form your company is, do you need a stockholders agreement? And what does that look like? Usually that would include, how do you elect your board of directors? Do your founders get seats? Are there any provisions or any voting actions that you want specific people to have consent rights over? Are there transfer restrictions on your stock? This has become more and more prevalent as the secondary markets have increased. So there has been more secondary action, meaning private company shareholders are selling their stock to other private investors as opposed to waiting for the companies to go public. And so it's often we see these days, companies will put transfer restrictions saying no one can transfer their stock unless you let the company buy it first, or you let the other investors buy it first, or unless you just get board approval. So think about those things and whether or not you want your investors to be able to sell their stock, or your employees, things like that. You may hear the term drag along. That will definitely come up when you start doing financing, but you may want to stick it in your documents to begin with. And essentially what that does is forces all of your stockholders to agree to sell the company if a certain percentage agree to sell the company. And it's just a mechanism to help you get through those sale processes faster. The other documents that you want to think about up front are your founders agreement and your restricted stock agreements. And we're going to talk about those on the next page. So founders agreements, if there's more than one founder in your team, think about what are everyone's roles and responsibilities. How do you fire a founder? If somebody's not living up to their obligations, is there a way to terminate their employment, terminate their relationship? Should founders be able to transfer their shares? Founders are going to own the majority of their shares for a very long time. So think about how they can transfer their shares. And then material decision-making. If you've got a founding team of 2 to 3 people, who's a tiebreaker? Do things need to be unanimous? Usually there's a list that are critical decisions that you say, these require a supermajority or these require unanimity. And then you would have a provision about resolving deadlocks. So particularly in even numbered founding teams, if you've got 2 founders, this is very important. Think ahead. How are you going to resolve disputes? If, for instance, the two founders diverge and one wants to take the business in one direction, one wants to take it in another, who resolves that? And we set up clauses like mediation clauses. So essentially you sit down with a trained mediator to figure that out, or a buy-sell provision to say, if we can't agree, then I get to make an offer to buy your shares, and you can either take that offer and walk away, or you can buy mine for that amount, something like that. And we always advise the founders think about this up front, when you're still friendly, when you don't think things are going to go wrong, when everyone's thinking with a cool head. And just think about it logically. What would you want to happen? And also, when you talk about founders' obligations, think about your stock. So if you issue founder stock evenly, so if there's 3 founders and you issue a third, that's great. That's fair. You know, you think that's the amount that makes sense, and you think that's the division that makes sense. But think about what happens if somebody leaves voluntarily. So if one of the founders decides, I want to go and pursue something else, they shouldn't get to keep all of their stock, most likely, because the other founders are continuing to work. And so think about time-based performance, or time-based vesting, so that the shares vest in, the most common we see is 25% a year for 4 years. Essentially says the founders should stick around for 4 years, and if they leave early, they lose part of their shares to keep the shares in the hands of the founders who are continuing to stay with the company. Also, in some cases, it may make sense to have performance-based milestones, particularly if members of your early management team, whether they're founders or just members you bring on very early, if they have different individual goals and different individual metrics, it may make sense to say, you vest 10% of your shares when you hit a certain milestone. It's not at all uncommon, once you get to be a larger company, that your employee options would vest based on company performance metrics. For instance, getting to trial, or getting through phase 1 trials, and people's options start vesting. So those are all things to think about, and think, who would you want to keep your stock and on what terms? The other thing to think about is buyback rights on vested stock. So the way a lot of people think about this is, once my stock is vested, I own it forever, which is true. But a lot of companies put in buyback rights in their documents so that the company can repurchase shares at usually at fair market value, or some predetermined value, if somebody leaves the company, so that they can keep a tight knit on who owns their stock going forward. It's not absolutely necessary, but think about whether or not that's important, to have only people who are either your institutional investors or your current employees continuing to own stock, and if that's the way you want to think about that going forward. A couple more things on startup documents: employment agreements or employee agreements, and some pitfalls that we would like to talk about, just to put them on the table very early on. Jamie will touch on a couple of these when she talks about your patent protection and IP protection generally, but the first and most important thing for any technology or med device or life sciences company is a confidentiality and assignment of invention agreement. Make sure a lawyer has looked at this. Make sure that it is appropriate for whatever state you are operating in. For instance, so this is the document that will say your employees have assigned all of their IP to the company that they're working on. Some states have very strict rules about how assignment of inventions have to happen and the limitations on that. For instance, California has very strict rules about this, and about what you can limit your employees from doing outside of their working hours. And unfortunately, in some states, if you don't draft that properly, the entire agreement can get thrown out. So just always consult a lawyer, always make sure that you have protected your confidential information and your inventions that are being created for the company. A couple of other things: incentive plans, option plans. Make sure you've put in place something to give your team some upside. As the company grows and the value of the company grows, giving them options to make them feel part of the team and also let them see the fruits of their labor is very important. Employment agreements for key employees. So employment agreements are not extremely common once you get past the C-suite. And there's a lot of reasons for that, but it's time consuming, but also there's not a lot of benefit, frankly, to the company, except to provide for non-solicitations. Non-competes, you'll hear a lot about that. Again, that's a state-by-state issue, and a lot of states have very strict non-compete rules. In California, we say they're virtually unenforceable, which is pretty much true, except in limited circumstances. In Massachusetts, as many of you may have heard, there was a non-compete law put in place a couple of years ago, which does allow non-competes, but there were very specific, stringent requirements on how to make those enforceable. So if you're thinking of non-compete, again, talk to a lawyer, see how narrowly you can tailor that, but do always think about non-solicits and your confidentiality provisions, because that's the best way to protect your company going forward. And then common startup pitfalls on employment matters. The biggest one we see is misclassification of employees and contractors. This is a tax designation, and a lot of people want to call people contractors because, frankly, their service providers want it. It's a tax beneficial arrangement for them, and they want freedom to take other jobs and things like that. But if you misclassify an employee as a contractor, you could end up with very large lawsuits coming from state AGs, coming from plaintiffs' attorneys and things like that. So consult employment attorneys to make sure that you're properly classifying people from the beginning. Similarly, make sure you're staying on top of labor laws, on wage and hour laws, and things like that. We have seen numerous times where people have gotten in trouble for not paying people the minimum wage that you're required, not because it was intentional, but because they were paying in stock or they were paying in some sort of other in-kind exchange, which may not be legal in your state where you're operating. Also, failure to document your employment terms is a big problem in a lot of early stage companies. Make sure that you have very clear policies on who can bind the company, who can sign contracts, whose job and whose duty it is to do each thing, so that you have a very streamlined process and your records are consistent going through. The other thing we'll say is inconsistent application of HR policies, whether it be severance, benefits, vacation policies, whatever it is, that can lead to bigger issues down the line, potential lawsuits. So while it seems a little cumbersome to put everything in place early, it really is important that you at least have a thoughtful process about what you're doing with your employment. And if you don't have a full-time HR manager, that's perfectly okay. A lot of companies don't, but there are great outsourced HR that you can hire as consultants to do this, 10 hours a month or something like that, to make sure that you stay within the bounds. So we always recommend that. I'm gonna move into financing, because I know that's important to everyone. A few early stage financing options are convertible notes or SAFE, and then a pure equity financing, which is a sale of your stock or your LLC interest. So when we talk about convertible notes and SAFE, we're gonna talk about those together. Convertible note is debt that converts into equity. It generally has a very nominal interest rate. It's a short term. We have 12 to 24 months is a very common term, and it can be shorter than that. It can be a little bit longer. The deal with convertible notes is you don't have to value your company now. So it's attractive to a lot of founders, because if you think your company is going to be worth significantly more in 6 months or 9 months when you hit a certain milestone in your development, it may be worth it to take a convertible note now to avoid having to raise money at a lower valuation. As a trade-off, your investors who can come in on a convertible note ask for a discount. So when they convert in, they say, okay, I'll convert into your next round of financing, but give me a 20% discount off that price. 10 to 20% is pretty common. You'll also hear some people say, give me a valuation cap. So I agree that I won't force you to value your company at $20 million today, but when my note converts, it can't be at more than $40 million or something along those lines. So it's to give your investors who are taking a risk on you early on a benefit, but also gives the founders and your management team the opportunity to not take as much dilution up front when you can't properly value your company or you're not comfortable valuing your company at that point. On the next slide, we'll talk about SAFEs really quickly. You may have heard of SAFEs. They are almost identical to a convertible note. The only difference is they are not technically repayable. They are not a debt instrument. They are treated like equity. You'll see a little asterisk there because there is a little bit of disagreement in the accounting world, although this is mostly everyone's gotten on board that this is equity. So it's not really a huge difference to you as a company. You won't have a liability on your books, which is helpful, but as an early stage company, that's not a huge issue. I would say this has just been more of a way the market has shifted to using safes as opposed to convertible notes. So you go to the next slide. A little bit of a note, safe pros and cons. You'll see they're very similar. In the pros column for both of them, we've got they're very cheap because they're very small documentation. It allows a lot of flexibility because you can use different discounts and different valuation caps for different investors, and you don't have to value your company super early. And there's very limited investor rights. So your note holders and your safe holders typically won't vote like stockholders on major actions unless they specifically negotiate for them. You'll see one more pro or a couple more pros on the safe side is there's no liability from an accounting standpoint on your books, which is helpful. And there's usually no maturity and no requirement to pay back. So it just converts to equity, and that's the only option. A couple cons. If you raise a lot on notes and safes, you can end up with a lot of discount when you go to raise your equity round. So sometimes that can be unattractive to investors. Investors almost always work it out, but it may end up in you having to do some renegotiating with your safe holders and your note holders. If for some reason you hit maturity, there's always this problem of what did you do if you didn't raise capital by the time you hit maturity. That's a technical con, but at the same time, if you haven't raised capital by the time you hit maturity, there's probably something else going on at your company that's a much bigger problem. And then also it's going to be your first to cash out in a sale or liquidation, or it's going to be a priority payment on a liquidation. So think of it like a senior equity security to everyone else. So if we go to the next slide, we'll talk a little bit about equity financing terms. For any of you who have been at companies that have taken venture money or angel money, any institutional kind of money, you may have seen these sorts of terms. Investors typically ask for preferred stock instead of common stock, meaning they have preferential rights, both in terms of voting and consent rights, but most importantly in economics. So the general rule is the preferred investors get their money back first, and then they participate with the common. There's different structures of that, whether they get their money back and then participate with the common immediately, or they get their money back and then the common gets paid until they get an equal amount and then everyone participates. But the general rule is they get their money back and then they're going to get some upside. They may ask for dividends. I will say for a long time, dividends were not, they were requested, but they were not accruing or anything like that. We're seeing a swing back toward accruing dividends to where essentially the preferred investors are saying, I want a guaranteed 6% return on my money or 8% return on my money or something like that. And that just accrues until a liquidation event. The other big thing to think about are consent rights. Your institutional investors are always going to ask for a list of consent rights over major actions at your company. That's usually going to be a sale of the company, related party transactions, so that you can't do a lot of transactions among family members, employees, and things like that. Incurrence of debt, amendments of the major financing documents and your certificate of incorporation, and possibly even consent rights over future financing. Although there's a lot of ways to structure that so that your investors can't actually block a future financing, but they just protect their own terms in a future financing. Also, board of directors, investors are going to want to see a balanced board. They're likely going to want board seats, but they also may want independent seats. Usually in the first round of financing, a founder may be able to keep enough seats between the management team to technically control the board, but the preferred will always have seats and possibly even have some specific director consent requirements on things as well. And then as the company grows, by the time you get to a B or C round, you're almost always going to have a balanced board where the founders no longer control, but maybe you have some independence and things like that. And then other basic things, information rights, rights of first refusal and co-sale, meaning if a stockholder transfers their stock, the investors get the right to buy it first. Registration rights, this goes to IPOs. If you're going to list the company publicly, then the investors get the right to register their shares so that they can also trade their shares. Pro rata participation rights, that you may have heard that be called preemptive rights, essentially just that the investors have the right to keep putting money in. If you go to raise a new round, then they have to have the right to buy up a portion of that round to keep their ownership percentage, because that's how a lot of investors think of this as, I want to maintain 5% of the company, I want to maintain 10% of the company. They'll have to buy that stock going forward, but they have the right to buy it because that's important to them. The last thing on here is redemption of preferred stock. So it's got an asterisk down there. I don't know if you can read that very clearly, but it says primarily in biotech and life sciences startups. So redemption is after a certain period of time, the preferred stock can tell the company, give me my money back. And we see it more in the life sciences space because those are the long-term investments. And with all the trials and all the development work, investors will say, after 7 years, I need the ability to get my money out, and you can take new money. It's not by any means in a majority of deals, but you may hear it come up, especially in this space. I think that's the last of my set discussion. If anyone has questions on the corporate side, feel free to throw them in the chat. We'll also save time at the end for questions. And then I'll turn it over to Jamie for IP.
Good morning, everyone. So I'm hoping today that I'll be able to give you a good introductory baseline, some practical tips, and just sort of an understanding of why IP, especially in early stage companies, is so important. And I know that everybody's situation is different and you're all at different stages. There's definitely opportunities for questions and continued discussion offline as well if anybody has really specific questions. But just to get started, the first slide, Mian, thank you. So just sort of an overview of the importance of having a strong IP portfolio. I think that a good way to think about your IP is that it really is a property that you need to protect. I like to think about it that, if you were to move and purchase a new house, that property you would take steps to protect. You don't leave your door open and let people come in to your property. So you want to take the same sort of steps to protect your intellectual property. It's really the core of what your company is. And it's important to protect that investment and all your research and development. And it really establishes value for your company, and it's important in obtaining financing. It's going to be a question that people are going to ask you when you have early stage investor meetings. And I think even if you haven't gotten to the stage where you've filed for any IP or gotten any coverage and protection, I think it's important to be able to convey that you understand that it's critical and important. Just as an anecdote, my husband's very involved in the angel investor community, and I know that in every investor meeting that they've had with founders, someone inevitably is going to ask about the IP strategy and portfolio. And I think that the answer that causes the most concern is not even really understanding why it's important at an early stage. It also can protect you, can be used defensively as leverage against lawsuits if you have corresponding IP. And it also can be important in protecting you in other foreign countries. Next slide, please. Just to give you an overview of the types of intellectual property that will be available to you, I'm really going to focus mostly on patents. A patent would be an exclusionary right that gives you the right to exclude others from making, using, or selling what is covered in your patent, your issued patents. There's also copyrights and trademarks. Trademarks might be something that some early stage companies could be interested in. You want to protect words, symbols, logos associated with your business. It'll help identify and distinguish you in your space from other companies. And just to touch really quickly on trade secrets, that's going to be some sort of like secret sauce to your company, some sort of proprietary information that gives you an advantage that you are confident that you can keep secret. I think you really need to think about who knows that information, and going forward, who's going to have to know that information in future hiring and future employees in order for your company to proceed. Because once that information gets out, if it ever does, there's no longer a way to recapture that and protect it. The key is keeping it a secret. It is enforced indefinitely, but you do have to really think carefully when you're making decisions about whether you're going to file for patent protection or keep something secret. How easy would it be for it to be discovered? Just to give a little more detail on patent rights, like I said previously, it is an exclusionary right, so it doesn't give you the right to do anything. It excludes others. So you really want to think really clearly about how you draft the claims portion of your applications. For anybody that hasn't seen an issued patent, the claims would be the portion at the end. It's a numbered list, and that really is where your protection comes from. It's a numbered list of the features of your invention that's protected in that particular patent. One thing I want to touch upon that's really important is timing of your filing. There is a 1-year grace period in the United States. Sorry, there is a 1-year grace period in the United States. So after an offer for sale or a public use, you still have a year to file your application. But in some foreign countries, they out the timing of filing. So I think for the practical matter, your best bet is to file early and file often. So before you're going to make a public disclosure, before you're going to publish an article or paper, the smartest and safest thing to do is to file before you make any public disclosures. It's just the safest option to make sure that you can get the coverage that you need. And in terms of the timing of the filing, next slide, please. So if we want to talk about the types of patent applications that you can file, one way to file early, even if you are not, your idea isn't fully fleshed out, is to file a provisional patent application. So it establishes your early filing date. And basically that date is really important because that's your priority date. That's the date that's used to establish the novelty of your invention against everything else out there, all the prior art, other publications, other patents. So that early filing date can be really important. To keep in mind, it is a legal patent document, but it is not going to become a US patent. You can think about it as sort of a placeholder. It gives you a year to file a full patent application, and it gives you time to develop your product, to think about your marketability, where you want to file, and to kind of flesh out any details that are necessary to get to that full patent application. One thing that is commonly done is during that year that you have to convert this provisional into a utility application, which is your full filing. It's common that companies will file additional provisional applications that build on the original. So you kind of incrementally add new inventions and new ideas to your first provisional application. So when you convert it in a year, you've kind of captured all of the innovation that's taken place in that first year. So your utility application can either be based on your provisional within the year, or you can file directly if you're ready to do so. The utility application protects the function of your invention, and it gives you a 20-year term of protection from the date of filing. The last type of application that you can file is a design patent. That's going to protect the appearance rather than the function. So it's a little bit more limited in scope. It is useful to prevent knockoffs. The term is slightly different. It's 15 years from the issue date rather than from the filing date. This really is done if the look and feel of your end product is going to be important. Just as an example, it's commonly done in the sneaker industry because the real innovation in sneakers is what they look like. So they are very prolific in filing design patents because that's where the protection is most important. To give you a little bit of idea of the timing of how the patent process works. So you can file, as I said, the provisional application. It gives you a year to file the full, and I apologize, I'm not sure why the full timeline isn't appearing on the slide. But you do, oh, there you go. Thank you, Mian. You do have that year to file your non-provisional or utility application. The patent prosecution process in the United States Patent and Trademark Office does take a couple of years. So you are probably not going to get to a final disposition and hopefully a US patent for 1, 2, potentially 3 years, depending on what your technology area is. You can see you also can do foreign filing at the time that you file your utility application, and I'll get to that a little bit later, but you can file. If you want protection in foreign countries, you need to file in each country that you want protection. And you can see that the timeline for when a foreign patent is going to be granted is even longer, because at some point you will convert your sort of placeholder foreign filing into individual countries. And just to give you an idea of what's currently going on in the US Patent Office, you can see on the next slide an idea of what the pendency currently is. This information is from January of this year. Once you file a patent application, it's about 16 months till you get what's called an office action, which is going to be your first substantive communication from the patent office about their thoughts on the patentability of your claims in your application. It's about 23 months, so about 2 years until an average patent will get issued, and you can see the backlog of unexamined applications in the United States Patent Office. So you can understand why it takes so long for them to get back to you. Sometimes for early stage companies, it can be important to try to speed this process up. There are some vehicles that can be used to decrease the pendency times from hearing back from the patent office. One example is called a track 1. You can apply to a petition to be considered a track 1 application. The patent office will take up to 12,000 track 1 applications per year. And what it does is, for a petition fee, it will speed up the patent process. There are some rules about the number of claims and how you have to respond to substantive actions from the patent office, but it does shorten the final disposition to about a year. That doesn't mean you'll get a patent after a year. It just means you will get to a place that they consider a final disposition. Hopefully, in most cases, we hope that that will lead to an allowance. I just wanted to touch on a couple of practical matters that if you do have IP counsel and you're filing patent applications, there's a couple of things that you'll probably hear about pretty often from your attorneys, and they will definitely talk to you about ownership, and kind of hand in hand with that will be inventorship. When you file, you need to list the inventors. And there are really specific rules about who is an inventor on your patent applications. It really all relates to invention conception, not reduction to practice. So if you have a team of people who are taking your ideas and performing tests and studies, if they haven't been involved in the conception of the ideas that they're working on, they would not be considered inventors of your application. So you need to be really careful about who you list. You don't want to get into trouble later on because you've listed a board member or your CEO who just wants to be able to see their name on the face of your issued patent applications. The patent office is very concerned about following their rules, and you don't want to get into trouble for something like adding an inventor that isn't really an inventor. There are ways to correct it. It's just always better to make sure you understand what they mean by inventorship and try to get it right when you're doing your filings. Going along with that is the assignment process. As Emily mentioned, you want to make sure that your agreements with your employees include clauses having to do with them signing their inventions over to the company. Whenever you do a filing, there's going to be documentation that goes along with it for your inventors to assign so that the inventions are owned by the company. And just as a practical matter, you want to make sure that you try to get those documents signed in a timely fashion. there can be a lot of fluidity with employment, especially at the early stages. And it's a lot easier to have those documents signed when an inventor is still working for you than when they've left and you have to try to track them down to have documents signed. And going along with that, that has to do with the chain of title issues from your inventors to the company. And one avenue that you can do now that's a relatively recent change in the Patent Office is that when you file your applications, your documentation can now list the company as the applicant rather than the inventors. That is helpful in the chain of title, but you do have to keep in mind that even if you do that during your filings, you still have to have those assignment documents executed and filed with the Patent Office before your applications issue into patents. Another area that you'd hear a lot about is the duty of disclosure. Everybody associated with the prosecution of a patent has a duty to disclose to the Patent Office information that's material to the patentability of your application. And everybody who is involved is implicated. So your attorneys, your inventors, any other company employees that are involved with the process. And you really want to take this duty to disclose seriously. It would not be in your benefit either during patent prosecution with the office or say during a potential future litigation for it to come to light that somebody knew about a relevant document or a competitor's patent and they did not disclose it to the Patent Office during the prosecution of that application. You don't want to have your application, your US patent thrown out because somebody kept a relevant document to themselves. And sort of one last practical matter, I just want to touch on sort of the idea of patentability versus infringement. I think it's important to understand the patent landscape of the technology area that you're in. One thing that you might hear about sometimes is people talking about freedom to operate searches. It would sort of be a search of your technology area, focusing on the key features of your invention to get an idea of what else is out there so that you can avoid infringement issues, so that you're not stepping on the toes of things that are already patented. The question that is always posed is how much searching is enough? In some ways it can be a business consideration because really extensive freedom to operate searches can be quite costly. There's also the issue of how much do you want to know? I think one sort of practical way to deal with freedom to operate questions is to monitor your closest competitors. If for relatively low cost, you can have monthly searches done that monitor the companies that you know that most closely relate to your technology area, just to get an idea of what the landscape is. So you can keep that in mind when you are innovating and when you're filing for your applications. It's just an easy, low-cost way to be able to keep an eye on the landscape. I just want to quickly touch on foreign filing. I mentioned earlier that you can file, if you want coverage in other countries, you need to file in each country that you want coverage in. So just to be clear, there is no such thing as an international or a regional patent application or patent, but there are processes that are in place that allow you to secure your foreign filing rights before you have to choose which countries you want to go into. You can file with the European Patent Office. They do give you really thorough prior art searches, so it gives you a really good idea of how foreign countries might view your application. I think more commonly, people will file what's referred to as a PCT application. You can think of that as a placeholder application that gives you a way to secure your rights into, it's currently up to 153 different countries around the world. And once you file your PCT application, it does defer the costs for quite a long time. And it helps you decide where your product might be the most commercially viable and which countries are important to your market and your product. You do also receive helpful documents from the PCT application process. You will get a search report and a written opinion, which gives you an idea of the types of references that they have found and how they view those references in light of your application. so you will not get an enforceable patent out of the PCT, but you will end up deciding which countries you want to file in based off of that application. And again, foreign filing can be a very costly process, and the more countries that you file in, the higher that cost goes. So I think it's a real business decision to think about which foreign countries are important to your business, where your markets are, potentially where your manufacturing might be done. There's also countries that have good enforcement records versus others. And it's really to think about which countries are you willing to enforce your patent rights in. If you have no intention of enforcing in a country, then there's really no point in filing there and sort of taking the time and the cost to go through that process. So I think you really need to think about where the important markets are for you. And I think that's a benefit of the PCT process, is that it gives you a lot of time for your product and your company to develop, to make those decisions. Just as a little, just some things we hear sometimes about why people are hesitant to file IP. I think probably the most common is the high cost. And I know I've touched upon that a little bit about how certain parts of the process can be costly. And I think that there are ways to use your budget and your resources to get the most bang for your buck in terms of protecting your company. And I think that, especially starting off with the provisional application process, when you're in the early stages, you get that protection, you get that filing date, and it gives you time to make decisions. And just my last slide, please. Just as an overview, I think that probably the most important takeaway would be filing complete applications that meet all of the legal requirements in a timely fashion. You want to make sure you have clear title. I think that you need to be aggressive on your core technology. You want to file often and file early on your the most important aspects of your company. And I think, as I touched upon, understanding the competitive landscape is also important by monitoring your competitors. And I think with that, I'll turn it back to Mian and see if there's any questions.
Thank you. Yes, we have some. The first question, I think it's to Emily. The question is, I hear a lot about having a digital room for due diligence. What are the basic documents you need to have organized to get ready for a C round? And then subsequently, if you structure with a holding company and separate entities for IP and the operating company, which entity do investors invest in? Oh, Emily, you're on mute.
Can you hear me now?
Yes.
Okay, so I'll take the second question first. If you structure with a holding company, the investors would generally come in at the holding company. So the point is that all of your investors will be up at the holding company level, and then all of the subsidiaries would hold IP or do different operations, things like that. We have seen structures where you have some investors come in on the individual subsidiaries. That is a far more complex structure and can create a lot of governance issues. But there is a scenario where that makes sense if people only want to invest in one technology and they're not all interrelated. But that would be a rare structure. On the data room for diligence, part of that depends on how early you are. If you are talking about a seed round where you haven't taken capital in before, you want to put your organizational documents, so your certificate of incorporation, your bylaws, any founder restricted stock agreements, any stock issuance documents, any minutes that you have if you've been holding meetings of the board or meetings of your stockholders, which you probably have not that early. And then any key contracts. So even seed stage companies sometimes have key licenses or things like that they've already negotiated. If you already have patents on file, or if you already have applications on file, maybe don't put those in the data room yet, but put a list of what you've got on file or what's been filed so that you can share that with the investors under confidentiality once they go public. So whatever you have that shows how you're currently organized, and then also what assets you have, investors are also going to look for a business plan if you have one. So put that in the data room if you have a slide deck, 3 or 4 slides showing what you plan to do, the basics of your company, anything that you can do like an executive summary, and always talk to your counsel. We have examples of all these things, but the general idea is your data room should be able to tell your investors, how are you structured, who owns your stock, what's your IP and asset situation, and what are your material contracts.
Great, thank you. The next question is for Jamie. How does reduction to practice play into the patent process? Is it necessary or otherwise beneficial in some way?
So I think when you think about reduction to practice, I think it goes along with some of the requirements of your disclosure and sort of what the patent actually is. It's sort of, you think of the patent as an agreement between you and the public. You're getting this 20-year exclusivity in exchange for teaching the public how to make and use your invention. So there are a number of requirements about your disclosure and your actual application that you have to comply with that relate to the written description. It has to be explained enough so that someone who's skilled in your art can make and use the invention. So I think that goes along with reduction to practice. I think there can be an actual or a constructive reduction to practice, but there has to be enough of an understanding that you can describe it fully to meet the requirements of what the disclosure needs to include.
Great, thank you. For the next question is, request to get a copy of the slide deck. Feel free to reach out to Emily or Jamie for a copy of the slides, as well as me. I will enter my email address into the chat box, and Emily and Jamie's contact information are on the slide. The next question is, I believe is for Emily. Roughly what percentage of deals by stage are participating preferred?
I'd have to pull a deal study to do it by stage. I think the most recent deal study I saw that aggregated data that we can aggregate to the extent it's public was about 20% or 25% was participating preferred. It's a little bit hard to tell. I think in my practice, early stage are very rarely participating preferred. You see it more pop up in the later stage. I'd still say it's exceedingly uncommon to see participating preferred, though we're seeing a swing back. So I'd have to pull an actual deal study on a by stage. One thing I will say is it is more common to stick with whatever has been done historically in the company than somebody to come in and change terms later. So it gives you a lot of leverage. If you start with not participating preferred, it gives you a lot of leverage to not have to go to it later.
All right, and then another question we have is, FTO searches are expensive, but one way to reduce cost is to informally analyze search results without formally completing the final report until major event like fund raise or sale. Emily and Jamie, any comments to that?
Yeah, I agree. I mean, I think they're important, but I think, like you said, they can be costly, and I think there are ways to reduce the costs. And like I said, I think that's why an excellent way to kind of deal with an FTO issue is to monitor your competitors. But I think, yeah, you definitely don't need to do sort of a final, come up with a final report on, everything you think you know about the landscape, especially at a really early stage.
And I'll just add one thing one thing to that from an investor perspective. We represent a lot of investors here as well as companies, and a freedom to operate is, investors generally know they're very expensive. So they don't necessarily expect you to have a true freedom to operate. But the other thing is they can go stale pretty fast, right? So doing one early doesn't necessarily help if it's a year later when you raise your capital, because then the investor is going to say, well, that's great, you had one a year ago, what's going on now? So always I defer to the patent team on whether it's economical to do it and when. But from an investor perspective, I think our investors typically want to see that the company's thought about it and they've had that discussion with patent counsel and somebody's looked at it. But a formal FTO often if it's going to be required, will be done in connection with your financing so that it's up to date.
Great. That's all the questions we have. So I want to thank everyone for joining us this morning. We would love to see everyone again in the part 2 of our presentation, which will be on March 24th at noon, where we will discuss, now that you have your formation and protection for your IP, some best practices about data management, privacy considerations, as well as risk management. Thank you again.
And thank you to our speakers. You all were absolutely fantastic. So thank you for putting this program on for us. It was incredible. So yes, hope to see everyone again on the 24th at noon, and have a great rest of your day.
Thank you.